Welcome to the deep dive. We've got quite the stack of legal documents here, all about proposed changes to business registration in Luxembourg. Avis, amendments, the whole shebang. So today we're diving deep into this draft law to see what it all means for businesses like yours. Expert speaker, are you ready to tackle this?
Absolutely. This draft law is a pretty big deal. It could really reshape how businesses operate in Luxembourg.
Okay, so from what I've seen, these documents seem to really focus on two main registers. The Trade and Companies Register, the RCS, and the Register of Beneficial Owners, or RBE. What's actually changing with those?
Both registers are getting a major overhaul. It's really about how data is collected and managed and accessed. Think more transparency, streamlined processes, but also more responsibilities for businesses.
So less paperwork, but maybe more hoops to jump through. That's a bit of a trade-off, isn't it?
Yeah, it is. One of the most impactful changes, though, is the move towards these interconnected databases. They're basically linking the RCS with the RBE and the National Persons Register, the RNPP, and a bunch of other relevant national databases.
So it's like one central hub for all this business data, kind of like a tech upgrade for the government. But how does this whole one-stop shop approach actually affect businesses, on the ground?
Well, think of it this way. Let's say you need to update your company's address. Right now, you'd probably have to notify a bunch of different entities separately. But with this new system, you update it once, and it automatically syncs across all those connected platforms. No more chasing down outdated information in different registers.
That sounds like it could be a serious time saver, especially for businesses that are, juggling multiple registrations. But I did see in the Chambre des Métiers à Vie that they're not exactly thrilled about having to collect gender information on everyone.
Right. They're saying it's not really relevant for most businesses, those operating as companies, not individuals. And I mean, the draft law is aiming to gather more statistical data for state tech, but whether collecting gender data at this level is really necessary or just an added burden is a valid point they're making.
Yeah, for sure. And the Council of State also seems to have some reservations about the whole thing, especially when it comes to data protection.
Yes, they're being very cautious about these interconnected databases. They're asking some pretty tough questions, like, is all this data sharing really necessary? Is it proportionate? It's the classic dilemma, right? Balancing the need for transparency with the right to privacy. They're really pushing for very clear justifications for every single piece of data that's collected.
Makes sense. Streamline things, but not at the expense of people's privacy. And speaking of access to information, there's a whole section here about journalists and the RBE.
Yeah, that's definitely a hot button issue. The draft law specifically talks about access to the RBE for journalists and civil society organizations. It kind of recognizes their role in promoting transparency, especially when it comes to fighting financial crime.
But it's not a free-for-all, right? It's not like just anyone can peek into the RBE.
Exactly. The draft law makes a distinction between national and international actors, each with different levels of access. So national journalists and organizations focusing on anti-money laundering and countering the financing of terrorism, AML-CFT, they get direct access. But international actors need to demonstrate legitimate interest to access the information.
That legitimate interest clause, it sounds like a bit of a gray area to me. Who decides what's legitimate? Couldn't that lead to bias or even censorship?
Well, the Council of State actually flagged this as a potential problem. They're calling for much clearer definitions to avoid any discrimination. And remember that recent CJUE ruling on RBE access? That adds another layer of complexity.
Right, that ruling limits public access to beneficial ownership information. It makes it harder for journalists and civil society groups to investigate potential financial crimes. So what does all this mean for the average business owner in Luxembourg?
It could mean a less transparent business environment overall. Less scrutiny might sound appealing at first, but it also creates opportunities for bad actors. A healthy business environment thrives on accountability.
Okay, so we've got these interconnected databases, these potential data protection concerns, and this whole debate about access to the RBE. What other big changes are in store for businesses under this draft law?
Well, one of the most significant shifts is that the RCS is taking on a much more proactive role in ensuring data accuracy.
Proactive. So are they going to be like data detectives,
Yes.
sniffing out inconsistencies? What exactly will change in practice?
You could say that. The RCS is getting serious about data quality. For instance, they're introducing this thing called inscription d'office. So basically, updates from other registers like the RMPP would automatically get reflected in the RCS. Let's say you change your company's name. This change would automatically update in both the RCS and the RMPP. No more manual updates across multiple platforms.
That's a pretty big shift from how things work now. Sounds like it could be a real game changer in terms of efficiency. But what happens if a business doesn't keep their information updated? What are the consequences under this new system?
Well, the draft law introduces the three-phase enforcement approach. So it starts with warnings, then moves on to administrative fines, and then ultimately, for the most serious cases, they can actually report you to the prosecutor. It's a system that's really designed to encourage compliance with consequences that, escalate depending on how serious the violation is. But the Council of State, they've actually raised some red flags about potential inconsistencies in how these sanctions are actually applied. They're arguing for a more nuanced approach, one that takes into account the specific circumstances of each case, rather than just a one-size-fits-all system.
So context matters. A minor oversight shouldn't be treated the same as a deliberate attempt to, mislead. And what about the RBE? How does this new focus on data accuracy play out there, especially with its role in, AML CFT?
Well, the RBE is also getting a pretty significant upgrade. The draft law proposes these measures to ensure that the data it holds is reliable and up to date. So they're introducing this system of continuous monitoring, which basically means the RBE manager will be regularly checking for any outdated or missing information, and then they'll contact the entities to request updates.
So no more hiding in the shadows of outdated registration details. They're really shining a light on beneficial ownership. But doesn't this raise some concerns about, potential misuse of this sensitive information?
Oh, absolutely. Balancing transparency with data protection is crucial. And it's not just about, who has access to the RBE, but also about ensuring the data itself is accurate and used responsibly. The CNPD, for example, has raised concerns about lawyers having to consult the RBE. They're arguing that limiting access to purely AML CFT purposes could clash with, a lawyer's duty of confidentiality to their clients.
That's a tricky situation. You want to combat financial crime, but you also need to protect the confidentiality of those client-lawyer relationships. It's another one of those balancing acts.
Exactly. And the Ordre des Avocats du Barreau de Luxembourg, they've also weighed in on this. They're saying that lawyers need broader access to actually fulfill their professional obligations effectively. I mean, to give good legal advice, they often need to understand the ownership structure of their clients' counterparties.
It makes sense that lawyers would need more than just a sliver of information to do their jobs properly.
Right. And the draft law does acknowledge that you need to ensure the RBE is a trustworthy and valuable tool for AML CFT efforts. And to help facilitate that, they're encouraging the use of electronic communication. So this kind of paves the way for more automated data exchanges, making it easier for entities to keep their information updated with the RBE.
Less paperwork, more digitalization. That seems to be a recurring theme in this draft law.
It is. It's all about modernizing the system and making it more efficient. And to further bolster the RBE's role in AML CFT, the draft law proposes a three-phase enforcement system, similar to the one for the RCS warnings, fines, and ultimately legal action for noncompliance.
So the message is pretty clear. Keep your beneficial ownership information up to date or face the consequences.
Precisely. And to really streamline things, they're also proposing to interconnect the RBE and RCS databases. Remember that one-stop shop concept we talked about earlier? This takes it to a whole new level. So updates made in one register would automatically flow through to the other.
So for example, if a company changes its beneficial owners, that information would instantly sync between the RCS and the RBE. No more manual cross-checking or worrying about inconsistencies.
Yeah, that's the idea. However, the Council of State has raised some concerns about the practicality and legality of this interconnected system. They're arguing that the draft law isn't clear enough on which databases will be linked and how this data exchange will actually function in practice, and what safeguards will be in place to protect data privacy and security.
It sounds like a good idea in theory, but those implementation details, they're crucial. What happens if one database has incorrect information? Could it spread to the others like a virus, create a domino effect of errors?
Yeah, that's a valid concern. The Council of State is pushing for clear guidelines and protocols to ensure data quality and to address any potential errors. They're also pointing out that interconnecting databases raises some complex legal questions, especially regarding responsibility. If there's, a data breach or inaccuracies, who is ultimately accountable? That needs to be clearly defined.
So while the goal of linking the RBE and RCS databases is admirable, it's essential to proceed cautiously and consider all the potential ramifications. It's not just about making things easier, it's about doing it right and protecting everyone involved.
Exactly. And the Council of State isn't alone in their concerns. Various professional organizations have also expressed reservations about certain aspects of the draft law. The Chambre de Métier, for instance, has questioned the need to collect gender data, arguing that it's not particularly relevant for their members and simply adds to their administrative burden.
It sounds like a chorus of, hold on a minute, echoing through the legal corridors. They're pushing back and demanding clarity, consistency, and a thoughtful approach to implementation.
Right. They're playing a crucial role in highlighting potential problems and ensuring that the final law is well-crafted and considers the needs of all stakeholders. After all, a law is only as good as its implementation.
This draft law has certainly sparked a lot of debate and discussion, but it's not just about these high-level concepts and legal technicalities. There are real-world implications for businesses like yours.
Absolutely. These changes, if implemented, will impact how you manage your business information, how you interact with different registers, and even how you think about data privacy and security.
And speaking of practical considerations, the draft law also proposes streamlining the process for companies going through administrative dissolution. This seems a bit out of place amidst all this talk about interconnected databases and AML-CFT.
It might seem like an odd addition, but it's actually part of a broader effort to make the RCS more efficient and effective. By making it easier to remove inactive companies or shell companies from the register, they're improving the accuracy and reliability of the data held by the RCS.
It's like cleaning house and getting rid of the clutter. I remember reading about some of the practical difficulties with the current process, especially with those registered letters they use.
Exactly. Right now, they rely on sending registered letters with acknowledgement of receipt to companies facing administrative dissolution. But this is a really cumbersome and often ineffective process, especially when you're dealing with companies that have what they call a siège dénoncé, meaning their registered office is no longer valid.
So they're sending these important legal notices to addresses that might not even exist anymore. No wonder it's not very effective. So what are they proposing instead?
Well, the draft law suggests switching to registered letters without acknowledgement of receipt. They argue that this still provides sufficient proof of notification while significantly streamlining the entire process.
It's like killing two birds with one stone, clearing out those inactive companies and modernizing that notification system all at the same time.
Exactly. It's all part of this overarching drive toward efficiency and digitalization. But while this might seem like a pretty straightforward change, it has raised some eyebrows. The Council of State has voiced concerns that this new process might not adequately protect the rights of those companies facing dissolution.
It sounds like they're worried that some companies might be dissolved without ever even receiving proper notification. That could have some pretty serious consequences.
Absolutely. The Council of State is pushing for robust safeguards to ensure that all companies receive adequate notice and have the opportunity to respond before any drastic action is taken.
So even seemingly minor changes can have these significant legal and practical implications. It's a reminder that the devil is often in the details.
That's precisely why it's so crucial to carefully analyze all aspects of this draft law, not just the attention-grabbing headlines. Yet those nuances in the implementation details, that's where the real impact will be felt.
Well, we've covered a lot of ground today, from interconnected databases to streamlined dissolution procedures. And that ever-present balancing act between transparency and data protection. But one question that kind of lingers in my mind: what does all this mean for the average business owner in Luxembourg?
It means change is on the horizon, but the final shape of that change is still being debated and refined. The draft law is undergoing this thorough review process with input from legal experts, professional organizations, even ordinary citizens. This ensures that the final law reflects a variety of perspectives and ultimately safeguards your interests.
So it's not a done deal. There's still room for discussion and potential adjustments, but what should our listeners be doing right now to prepare for these potential changes?
First and foremost, stay informed. Keep an eye on the developments surrounding this draft law and engage in the conversation. Make your voice heard. Share your concerns or suggestions with the relevant authorities.
Don't just be a passive observer. Participate in shaping the future of the business environment in Luxembourg.
Exactly. And remember, this deep dive is just the beginning. There's a wealth of information in these documents, and it's really worth taking the time to explore them further and understand how these changes might affect your specific business.
We've given you the highlights, but now it's up to you to dig a little deeper and uncover those details that are most relevant to your situation.
And as this draft law continues to evolve, it's essential to stay engaged and informed. The business landscape in Luxembourg is changing, and understanding these changes is a first step towards navigating them successfully.
Well, we've certainly covered a lot of ground today, but as always, there's still more to explore. Back after a short break to delve into some of the criticisms and concerns surrounding this draft law and what they could mean for the future of business registration in Luxembourg. Welcome back to the deep dive. We've spent some time, exploring these major changes to business registration in Luxembourg. But like we've mentioned, not everyone's completely on board with every single detail.
That's right. There are a lot of Avison amendments, just packed with criticisms and concerns. And it's really important to understand these dissenting voices because they can actually help shape a better, more effective law in the end.
The Council of State, for instance, they seem to have a lot to say about this draft law.
They do, and their role is really crucial. They basically provide this independent legal advice, and they make sure that any new law aligns with the Luxembourg Constitution, and that it protects fundamental rights. Their analysis of this draft law is pretty extensive. It raises several really important points that are worth going over.
Okay, so let's dive into those main criticisms. What are they saying about data protection, especially with all this talk about, interconnected databases and expanded access?
Well, they're really emphasizing that any data collection has to be justified. It has to serve a clear legal purpose. They're not against transparency, but they're very, very insistent that collecting data should be proportionate and necessary, not just nice to have. They also want strong safeguards in place to make sure that data privacy and security are protected.
So it's all about responsible data management, not just gathering information because you can, but because there's a real valid reason, and you're going to handle it carefully.
Exactly. And the Council of State wants to see very specific guidelines on which databases are going to be interconnected and how the data exchange is going to actually work. And, what measures will be in place to prevent misuse of that information. They're also really big on clarity in the law itself. They're arguing that some of the draft law's provisions are just too vague or they give too much power to the executive branch.
So they're basically saying, don't just tell us what you're planning to do, show us exactly how you're going to do it and make sure it's all above board.
Yes, they want those rules clearly laid out in the law, not left to be defined later on in regulations. It's about ensuring legal certainty and the separation of powers.
They also raise some concerns about, potential inconsistencies in how sanctions are actually applied.
Right. They're questioning that fixed fine system for certain violations, arguing that it doesn't actually take into account the severity of the offense or the specific circumstances of each case. They also want to make sure that that administrative dissolution process is fair and transparent, so that companies aren't dissolved without proper notification or a chance to respond.
That sounds like a real nightmare for a business owner. To just have their company suddenly disappear without any warning, that would be incredibly disruptive and unfair.
Absolutely. The Council of State is advocating for a more balanced and nuanced approach to enforcement, one that considers the context and ensures due process. And they've also flagged some practical concerns with the proposed changes, like collecting national identification numbers for foreign executives.
Right, because not every foreign executive who manages a company in Luxembourg will necessarily have a Luxembourgish identification number. So how will that information be collected and verified, especially for executives who don't even reside in Luxembourg?
It's a valid question. The Council of State is definitely pushing for practical solutions that actually work for everyone involved.
Okay, so we've got the Council of State advocating for these clearer rules, stronger data protection, more consistent and fair enforcement. What about the other professional organizations? What are their main concerns?
Well, a lot of their concerns echo those of the Council of State, particularly around data protection and how these changes might affect their ability to carry out their professional duties.
The Ordre des Avocats, for example, they've expressed concerns about access to the RBE.
Right. They're arguing that limiting their access to purely AML-CFT purposes could actually hinder their ability to provide effective legal advice, to assess potential conflicts of interest and to provide sound counsel. They often need a more comprehensive understanding of the companies involved in a transaction, not just a limited view focused on AML-CFT concerns.
So it sounds like a lot of these criticisms come down to finding the right balance. transparency versus privacy, efficiency versus security, and, the need for strong enforcement versus the importance of fairness and due process. It's a really complex equation with no easy answers.
Absolutely. The challenge for lawmakers is to create a system that actually achieves its goals without unintended consequences or placing these undue burdens on businesses.
So what does all of this mean for our listener? What's the takeaway from all this debate and discussion?
It means change is coming. But the final form of that change is still being worked out. The draft law is going through this really robust review process, and that's a good thing. It means that a range of voices are being heard, and hopefully the final law will actually reflect a thoughtful and balanced approach.
So rather than feeling overwhelmed by all of this, this mountain of legal documents and all these differing opinions, our listener should see this as an opportunity to engage in the process and to make their voice heard.
Exactly. This is your chance to help shape the future of the business environment in Luxembourg. Stay informed, understand the issues, and, participate in the conversation.
And remember, this deep dive is just a starting point. We've given you the roadmap, but the real journey is in, exploring these documents further and really understanding how these changes might actually affect your specific business.
We've highlighted the key points, but the details are where the real insights lie. And as this draft law continues to evolve, it's essential to stay engaged and informed. The business landscape in Luxembourg is changing. And, understanding these changes is really the first step towards navigating them successfully.
Well, we've certainly covered a lot of ground today, and thanks for joining us on the deep dive. We'll be back soon with another fascinating topic. Until then, keep learning, keep questioning, and keep diving deep.